Greetings from Bharat Institute of Law. Myself, Archana, Assistant Professor, Bharat Institute of Law, Bharat Institute of Higher Education and Research. In this session, we'll be discussing about the international perspectives of environmental law. This topic is covered under environmental law. In this particular session, we'll be dealing with the international perspectives in two different ways. One is by analyzing the basic fundamental principles that governs the international law relating to environment. The second is the international instruments that provides for protection of environment. We will also be dealing with two international case laws relating to environment protection. Let's now move into the session. As said earlier, we will first deal with the fundamental principles relating to international environmental law jurisprudence. The first and foremost fundamental principle is the state sovereignty. We all know state sovereignty is one of the oldest principles of general international law. It means that state has jurisdiction on its territory. In other terms, the state is the only authority which can adopt obligatory legal rules for its territory, has the executive power, and its tribunals are the only ones competent to judge litigation. It is interesting to note that some components of the environment raise serious problems for the application of state sovereignty since the environment knows no boundaries. Migratory species of wild animals, fish stocks crossing the limits of territorial sea or exclusive economic zone, pollution of sea, etc. are not stopped by the limits of territorial jurisdiction. Such situations lead to conflict between sovereign rights, which can be solved only by international law. This is the object of a large part of international environmental law, since exclusive jurisdiction of the state on its territory also includes the right that its environment should not suffer damage caused by the activities that are outside its jurisdiction. State sovereignty is not completely or absolutely upheld when it comes to matters relating to environment under international law jurisprudence. The next principle is cooperation. In the field of environmental protection, international cooperation is necessary to conserve environment in its totality. Cooperation between states for environmental protection appears most often in the work of international organizations. Many environmental problems cannot be solved by the simple adoption of a regulation. They need ongoing cooperation between the concerned states. Provisions under Stockholm Declaration and Rio Declaration and some other international instruments also upholds this principle of cooperation among the sovereign countries. Rio Declaration insists on the cooperation to strengthen endogenous capacity building for sustainable development by improving scientific understanding through exchange of scientific and technological knowledge and by enhancing the development, adaptation, diffusion and transfer of technologies, including new and innovative technologies. The funding of international actions and financial assistance to countries in order to allow them to comply with their obligations is also an essential part of cooperation, especially in relations between industrialized and developing countries. The next principle is Preservation and protection of environment. The principle of preservation and protection of environment is another essential basis of international environmental law. There is no official definition of the terms protect and preserve. Protection can be seen as a general principle which includes both abstaining from harmful activities and also taking affirmative measures to ensure that environmental deterioration does not occur. Preservation could be considered as including the long-time perspectives which take into account the rights and interests of the future generations for whom the natural resources should be safeguarded. The term conservation is generally used in the field of living resources and is based upon the status quo, mainly demanding the maintenance of the conditions necessary for continued resource existence. The next principle is principle of prevention. It can be considered as a golden rule for environmental protection. It is not always possible to cure environmental injury or damage, the extinction of species of flora or fauna. Even if the damage is repairable, the cost of rehabilitation is often prohibitive. So this is the reason why prevention is considered as a golden rule for environment protection. As a matter of fact, the objective of almost all the international environmental agreements is to prevent environmental deterioration, whether they concern with the pollution of sea, of the atmosphere, or the protection of living resources. The next principle is precautionary principle. While the principle prevention still remains the general basis for environmental protection measures, the precautionary principle can be considered as its most developed form. Like prevention, precaution also seeks to avoid environmental harm, but it is to be applied when the consequence of non-action can be particularly serious or irreversible, such as large-scale degradation of environment or extinction of a species, etc. The next principle is the polluter pays principle. So this principle makes the polluter liable to pay compensation and the cost to remedy the environmental harm caused. This principle is considered to be the most effective way of allocating the cost of pollution prevention and control measures introduced by the public authorities to encourage the rational use of scarce environmental resources. According to this principle, the polluters should pay for the expenditure of pollution control measures such as the cost of running anti-pollution installations, the investment in anti-pollution installation and equipment and introduction of new processes so that the necessary environmental quality objective is achieved. The next important principle is the principle of sustainable development. Sustainable development is now a widely accepted principle as a primary goal of economic and social activities. Sustainable development suggests that the primary focus of environmental protection efforts on the international level should be to improve the human conditions. The Brundtland Report defined sustainable development as development that meets the needs of the present without compromising the ability of future generations to meet their own needs. But The United Nations Environment Programme clarified that sustainable development implies progress towards the national and international equity, as well as the maintenance, rational use, and enhancement of the natural resource base that underpins the ecological resilience and economic growth. The Rio Declaration also states that in order to achieve sustainable development, environmental protection shall constitute an integral part of the development process and cannot be considered in isolation from it. The next principle is intergenerational equity and responsibility. The term itself suggests that it is closely related or associated with the Sustainable Development Principle. The intergenerational equity and responsibility principle is considered as one of the central components of the principle of sustainable development as held in the United Nations Conference on Environment and Development, which we call as Rio Declaration in short. The declaration also states that the right to development must be fulfilled so as to equitably meet development and environmental needs of the present and future generations. The next principle is common but differentiated responsibilities. Sustainable development poses a common challenge to all countries, but because of different development paths, industrialist countries may be asked to carry more of the immediate burden. Under any circumstance, developed countries explicitly acknowledge their central responsibility for existing environmental degradation and the remedies for the same. The developed countries acknowledged their responsibilities that they here in the international pursuit of sustainable development in the view that pressures their societies place on the global environment and of technologies and financial resources they command. The developing countries also point their accusing fingers towards the developed countries for the current state of affairs. So, to solve the above said problems, the differential responsibility is incorporated in many recent international environmental agreements. To say an example, the Climate Change Convention's guiding principles directs the developed countries to take the lead in combating climate change and its effect while giving full consideration to the need and special circumstance of disproportionately burdened developing countries. The next principle is information and assistance in environmental emergencies. The Rio Declaration proclaims that states shall immediately notify other states of any natural disasters or other emergencies that are likely to produce sudden harmful effects on the environment of those states. The customary duty to notify the environment crisis has developed in a general fashion and is now included in numerous international treaties. For example, Article 198 of the Convention on the Law of Sea states that when the state becomes aware of the cases in which the marine environment is in imminent danger of being damaged or has been damaged by pollution or any other act, it shall immediately notify other state it deems likely to be affected by such damage as well as competent international organizations. According to these principles, states have a duty to inform other states which may be affected by any emergency situation arising from the utilization of a shared environment or environmental resources which might cause some sudden harmful effects on their environment as well as of any sudden grave natural disaster related to the shared resource which may affect the environment of such states. This principle also reiterates that the response to environmental emergencies must be organized in order to ensure prompt and effective action in which notification is only the first step towards it. The next principle is information and consultation in cross-boundary relations. Apart from the emergency situation where urgent notification and possible assistance are required, a state which plans to undertake or authorize the activities capable of having measurable effects on the environment of another state has a duty to inform the latter and also has a duty to transmit it to transmit the pertinent details of the project. Rio Declaration also states about this principle. According to this declaration, states shall provide prior and timely notification and relevant information to potentially affected states on the activities that may have significant transboundary environmental adverse effects and shall consult with those states at an early stage and in good faith. So this principle states that the notification of such projects must be prior and timely. This means that plans must be in an initial stage when the other state is notified of a particular activity so that they can be modified or the selected site can be displaced and even the activity can be delayed or prohibited, taking into consideration the environmental impact that it may have on the other state. One particular term to be noticed under the Rio Declaration is the term good faith. So good faith is a reasonable requirement in international relations and it is particularly important in the field of transboundary effects of certain activities. The last fundamental principle relating to environmental law under international jurisprudence is the equality of access to procedures and non-discrimination in environmental matters. So this principle of equality contains mainly four elements. They are informing the non-residents, allowing their participation in decision-making procedures, permitting the possibility to appeal in case of inadequate application of relevant rules, and providing remedies in case of damage. The principle of equality of access provides that if the activities taking place within the limits of jurisdiction of one state cause or threaten deterioration of the environment of another state, the residents who face the risk of being affected should have the access to administrative or judicial procedures in the state causing the environment harm under the same conditions as the residents of that particular state. The rule of non-discrimination is related to the principle of equality of access, but it concerns substantial rules of environmental law. It means that a state may not discriminate in its legislations according to the source of environmental harm by applying its laws less rigorously to activities which produce harmful effects only outside the territorial limits. For example, A factory which is on the border, if it discharges all its polluting substances into an international river, which immediately leaves its territory, the state must apply the same rules as for discharges which remains inside the limits of its jurisdiction. So that's all with the fundamental principles of international environmental law jurisprudence. Now let's look into some of the important international instruments relating to environmental law. We can say that recent few decades witnessed a remarkable growth in the level of understanding of the dangers facing the international environment. Taking into consideration that the environmental pollution knows no geographical or political barriers, and the problem of environmental pollution is a global problem. Pollution in one state does not only affect the environment of that particular one state, but also causes environmental degradation in the neighboring states as well. Because of these reasons, only environmental laws under international arena is in place. Though various international instruments were brought into place only a few decades ago, the international concerns over environmental protection is more than a century old. So the earliest bilateral treaty known is signed between France and United Kingdom on fisheries in the year 1867. So it was a bilateral treaty, and the earliest multilateral treaty known is the Convention on Protection of Birds Useful for Agriculture, was signed in the year 1902. Currently, we have about 174 international instruments that deal with protection of environment directly and indirectly. There are different international instruments under different classes. There are international instruments meant for protection and conservation of flora and fauna, deforestation, protection of marine resources, instruments dealing with transboundary pollution, marine pollution, ozone depletion, desertification, climate change, etc. One of the earliest convention on protection of flora and fauna is the International Convention for Protection of Birds, which was signed in the year 1950. The most recent international agreement on protection of flora and fauna is the Convention on Biodiversity, signed in the year 1992. The International Tropical Timber Agreement, signed in the year 1983 and 1994, can be considered as an example that is against deforestation. United Nations Convention on Law of Seas, signed in the year 1982, and International Convention for Regulation of Whaling, signed in the year 1946, can be considered as an example for instruments that are meant to protect marine resources. Convention on Long-Range Transboundary Air Pollution, 1979, and Convention on Environment Impact Assessment in Transboundary Context, 1991, are some examples for international instruments relating to transboundary pollution. International Convention on Civil Liability for Oil Polluting Damage, 1969, and International Convention for Prevention of Pollution from Ships 1973 are examples of international instruments meant for prevention of marine pollution. The Vienna Convention for Protection of Ozone Layer 1985 and the Protocol on Substances that Deplete Ozone Layer, famously known as the Montreal Protocol 1987, are the international instruments against the ozone depletion. The resolution signed in the year 1977 in the United Nations Conference on Desertification is an international instrument that is against desertification. And with relation to climate change, the United Nations Framework Convention on Climate Change, signed in the year 1992, is a significant international instrument, and the Kyoto Protocol to the United Nations Framework Convention on Climate Change, signed in the year 1997, is also a significant international instrument related to climate change. The conventions related to environment protection is not limited to these. As said earlier, there are more than 175 conventions and international instruments that provides for protection of environment globally. Apart from these conventions, there are also other declarations. There are majorly 5 declarations which are meant for protection of environment. They are the United Nations Declaration over Permanent Sovereignty over Natural Resources, signed in the year 1962. The Stockholm Declaration of the United Nations Conference on the Human Environment, signed in the year 1972. The Hague Declaration on the Environment, signed in the year 1989. The Rio Declaration of the United Nations Conference on Environment and Development, signed in the year 1992. And the Johannesburg Declaration of the World Summit on Sustainable Development, signed in the year 2002. Though the declarations have only persuasive value and it has not got any sanction, it is interesting to note that most of the countries have adopted the principles laid down in these declarations in their laws, in their domestic laws. The fundamental principles that we have discussed earlier has also been included in these declarations, and many of the states have adopted those principles and the provisions of these declarations in their national laws. In some other session, we'll discuss about the provisions of these declarations and major international instruments on environment protection in detail. Now let us see 2 case laws relating to international environmental law. The one is the trial smelter case. The Columbia River has its source in Canada and flows through United States. A smelter that is established in Canada releases zinc and lead in large quantities to the Columbia River. But the pollution has been caused not only to the states or places in Canada, but also to different states in United States as well. So this matter was referred by the United States before the International Arbitral Tribunal in the year 1941, and it was held that every state is having a responsibility to protect other state against the injurious acts. Here, Canada was ordered to take measures in order to stop the pollution caused to River Columbia that affected United States also. The next is the famous nuclear test case. In this case, Australia and New Zealand sought declaration against the French nuclear testing. The contention was before the International Court of Justice. it was contended by Australia and New Zealand that the nuclear testing was done without the environment impact assessment. The International Court of Justice upheld that nuclear testing is a lawful activity and a state can be made liable only if any damage is caused to the neighboring state. Though there was no direct damage caused to Australia and New Zealand in the French nuclear testing, the case observed that there is a need to take preventive measures in order to avoid any damage that may be caused to the neighboring states. So this is an instance where the sovereignty of a state was still upheld. That's all with this session. Thank you.